Hello, all, and welcome to another time on PUL341 Criminal Law 2. Today we are on to topic 6, and in topic 6, we shall be talking about the Public Complaints Commission. Like some of the bodies we mentioned on the other time, this is another body that also relates to checking of corruption in Nigeria. So we shall end up with the Public Complaint Commission as to with together with the other ones, like I said, we've mentioned before, like the EFCC and the ICPC and others, the Money Laundering Act and others that we looked at on checking of corruption in Nigeria. I'm Dr. Akujobi Alera, your facilitator for this class. So the Public Complaint Commission is basically a body that also checks corruption, though not specifically created for corruption issues, and it's established in 1975 by Decree Number 31 of 1975 and amended in 1979. Although, like I've said, it's not directly involved in corruption cases, its investigative powers makes it relevant in checking corruption in Nigeria, and it has powers under Section 5 of the law to make complaint, inquire into complaints lodged by members of the public. It could pertain to any administrative action taken by the government, state or local, public institutions, companies, and all of that. Like even as a student, you could also make a complaint to the Public Complaint Commission where you feel that something has been done wrong, your rights have been trampled upon, or you want to be making a complaint that has not been looked at over the time. And of course, the commission will look into such a complaint. So, like I said, it also can include cases of allegation of extortion by court officials, demand for gratification, suppression of appeal by judicial officers, unlawful arrest by the police. These are all some of the things that can be brought before the Public Complaint Commission. It is not prohibited from inquiring into matters pending or relating to the uh, National Assembly. That is, for those matters that are pending or relating to the National Assembly, it is prohibited from inquiring into those matters, before them. So, fact is to say that it is also a body that can look into corruption cases, even though it's not specifically uh, built or created for that purpose. Today, which I'll be looking at court and judicial officers. So basically, these are the courts that we have, and they also have the judicial officers that are also appointed for these courts. Like we have the judges, the magistrate, the justices of the higher courts, and things like that. Then the magistrate court is suffice to know that they are empowered to administer both the common law and equity concurrently, with equity prevailing in certain circumstances. This we all know. They are also empowered to look into legal and equitable remedies, and of course, matters pertaining to native law and custom, provided they are not repugnant. And we should also have it at the back of our mind that the magistrate court takes care of almost 80% of matters in criminal matters. Okay, so a magistrate has powers also to preserve preservation of the peace. He has powers to dispel a riot. He has powers to administer oath. He also has powers to determine and make punishment of offences, other than those offences that are triable on indictment, those offences that are not capital offences, So these are some of the powers that the magistrate has. And as practicable as possible, all matters in controversy are completely and finally determined and finally determined by or avoided as the case may be. So it is legitimate for the magistrate court also to encourage reconciliation, not only in civil matters but in such criminal matters as that involve simple offences or misdemeanor and not felonious offences. Um, we should also note that the magistrate differ in grades according to the grade. It's a state creation, and it has different grades of magistrate differing in matters of jurisdiction and powers. So, in the magistrate court, trial the law creating certain permits the magistrate court to try some indictable offense, but there are limitations, like I said, which varies, and also like I said, there are different grades of magistrate court, magistrate grade 1, magistrate grade 2, and things like that. Now, the federal and the state high courts, by the provisions of the 1999 Constitution, both the federal and state high courts have jurisdiction to hear and determine criminal matters. Now, the criminal jurisdiction are provided by the 1999 Constitution from time to time as prescribed by the House of Assembly. Again, we are aware of the conflict or jurisdictional conflict between the federal and state high court. However, this has been resolved by the provisions of Section 251, subsection 3, 251, subsection 1, subsection 3 of the 1999 Constitution. So, the Federal High Court, as we have it now, was originally the Federal Revenue Court until it was renamed the Federal High Court. And it is a court of first instance for matters going before it. Okay, its provisions are in sections 228, 230 of the 1999 Constitution. Um, Now, let's look at the Court of Appeal. The Court of Appeal has appellate jurisdiction in criminal matters, and we currently have like 72 Court of Appeals spread across the geopolitical zones of Nigeria, with its headquarters in Abuja. It comprises of the President and not less than 49 justices of the Court of Appeal. The Supreme Court, like I said before, is also a superior court of record, has no original jurisdiction in criminal matters. It only has appellate jurisdiction, and it's also headed by the CJ and the Chief Justice of the Federation, and it has a capacity for 21 justices. Currently, although they have 16 sitting. So Section 230 provides for its establishment. An appointment of justices to the court is by the President on the recommendation of the National Judicial Council. We have special courts or courts of special criminal jurisdiction, and briefly we shall just look at them as one, the juvenile court that has jurisdiction over cases and young persons, uh, cases involving children and young persons in need of care and protection. Now, of course, we know that these persons are in need of care and protection, and it is not it's not the position of the law to expose them to public, as it could affect their psyche, considering also that they are future leaders of the country. So the law is also very careful in matters that concerns them, and they include persons under the age of 17 years. That is in Nigeria. However, Section 29(4) of the 1999 Constitution defines a minor as below the age of 18 years. A young person is one between the age of 14 and 18 years. We know normally in the country, any child above 18 years is presumed to be an adult as provided for by the Constitution. As at that age, you can vote and be voted for, and you are presumed to have you are presumed to be responsible for your acts and your omissions. The court has power to look into cases involving juvenile delinquency and things like that, traffic matters, parental cases, and paternal cases, and things like that. Again, some of the features of the juvenile court is that it's not open to the public. It's not one that has been found guilty or found wanting. It's not normally convicted. Instead, guilty shall be recorded for such a person. The juvenile also cannot be imprisoned where they can be suitably dealt with otherwise. Again, where found guilty of death, cannot be so sentenced as he has not attained the age of 18. So basically, those are the features of the juvenile court, and like I said, their creation is for the care and protection of those under the age of 17, or as the case may be. Now, also concerning we have the Child Rights Act that also takes care of their provisions under the law. So the court martial is a creation of the Armed Forces Act, Section 130, and it has jurisdiction over persons subject to service law. Talking about service law, you're referring to the Air Forces, the Navy, Army, excluding the police. Now, it has power to try the following cases: insubordination, sodomy, drunkenness, conduct unbecoming of an officer, and such others as provided. Then lastly, or second, before the last, which I'll be looking at coroner courts. These are courts of inquest, that is to investigate into the time, identity, and cause of death of a deceased. And where it does not conduct trial but merely inquiries. And how does it do this? By calling witnesses and admitting evidence. Its investigation can lead to charge against an accused person. Finally, we shall look at tribunals. Tribunals are set up by the federal government with exclusive jurisdiction, uh, are geared towards speedy prosecution of cases and punishment of those persons who are deemed to have contributed to the nation's adversity. The main reason for setting up tribunals, I think, are for speedy dispensation of cases. They are empowered to try such offences as advanced fee fraud, drug possession, abuse of public office, and and the likes. So basically, we shall look at the role of the judiciary. We will know that the judiciary is an arm of government that is vested with judicial powers. The system of courts in the country, um, it also, its role is to interpret, construe, and apply the law. Is to construe and apply the law. So what it does basically, it interprets what the law is. It serves as a check on the exercise of the legislative and judicial powers. You know, in fact, in most times, it's regarded as the guardian of the Constitution, but it ensures that the Constitution, that is, the court does what the Constitution says or interprets it according to the provisions of the Constitution. So that is why it is deemed to be the guardian of the Constitution. It also look into matters of enforcement of individual fundamental rights. Where have they been violated, and where is it likely to be violated? It ensures the defense and maintenance of the rule of law. These are all functions or roles of the judiciary. It helps to ensure to sustain peace and order. So whatever tax is, whatever how bad it is, one of the essential role of the judiciary is to ensure peace and order in a democratic society. It helps to also uphold fundamental human rights. So again, basically, we've seen that in the administration of justice, the court or judge determines justice to the state, to the victim, and also to the accused person. So, what all this amounts to is a general recognition of the rule of law as the guardian of the Constitution, as the defender of the rights which the Constitution has guaranteed the citizen. It's an insurer against arbitrariness in the exercise of power. Exactly, this is one of the basic roles of the judiciary, to ensure that there's no arbitrariness of power, to ensure that it's able to carry out its functions properly, to ensure that the fundamental rights of the citizens are being protected, and when likely to be violated, they step in to ensure it is not so done. It is a vehicle for settlement of disputes, either between individuals and the state, between individuals and the federal government, within accepted principles of law and procedure, and just to ensure that persons or citizens do not resort to self-help measures. The judiciary is there to help in the settlement of disputes. And finally, like I said before, it is a guarantor or a guarantor for the maintenance of law and order in a democratic society. The judiciary will be there. It acts as check and balances on the other arms of government. It also ensures to maintain decorum, to maintain law and order, to maintain peace in a democratic society. So, whatever questions you have on this topic that we've talked about, please make it available on my email so that we can look at them and answer them too. Thank you for your time.